The time has finally arrived. We've arrived at what can clearly be the best panel of the afternoon. And congratulations and thank you to you all for lasting the course. It's been quite a day. Can I also thank Eleanor and Tuvi and Brown Rudnick for organising such an amazing day. It really is incredible. And it's amazing, the litigation financing industry has finally come of age. Now, can I also thank you for keeping what is our panel to the very end. So I don't know whether that was deliberate, Eleanor. But before we met the panelists, and I'll tell you a little bit about that in a while, but we all discussed together what we were going to say. And one of them described the CAT regime as being the sexy part of litigation. Now, I suppose we're going to have to wait for the next 50 minutes to see whether you were right, Adam. But before I kick off, let's just introduce the panelists. And you're seeing them here. They all look very calm and relaxed. We have had a few changes. There are a number of people who tried to come and join the panel, and we would like to thank them for that. So unfortunately, they didn't make the grade. So Adrian, if you're here, we appreciate you acting as stand-in, but maybe better luck next time. But Julian, do you want to kick off and introduce yourself?
Yeah, I'm Julian Gregory. I'm a barrister at Monckton Chambers, competition law specialist. I think doing exclusively claimant side work at the moment, and quite a lot of collective proceedings claims. I'm in the Google ad tech claim, the Roberts sewage claims against the water companies, and I'm preparing one which has been press released, which would be against Valve, which runs Steam, the PC games platform.
Jenny?
I'm Jenny Morrissey. I'm a partner at Harkers Parker. I'm one of the last-minute stand-ins to the panel, and one of the things standing between you and your glass of wine. But I'll do my best to comment on some of the CAT cases, even though it's not my area of specialty. But we do a lot of Greek actions and funding in the firm, so we've got a good grasp on that.
Great, thank you. Jen, who left it literally for the last few seconds, I think.
Yeah. Can you hear me? Is this
yes,
working?
Yeah.
Oh, hold on a minute. No, it's not.
Want some help?
It's not working. How's that?
Perfect.
It's the problem with artificial material, isn't it? This would go up very quickly if you brought a live flame near it. I'm a partner at Stevenson Harwood, and I specialise in competition claims, along with corporate claims, oddly. It's a very strange mix. And I got in a cab and then ran here in the rain because the cab got stuck from the Competition Appeal Tribunal, where we are 4 weeks into a 6-week trial on the merchant umbrella interchange claims. So I will, unfortunately, be telling you about those, but not for too long.
Adam?
I'm Adam Erusalimsky. I'm an investment manager at LCM. I joined the litigation funding world in 2019, initially at Woodsford, and moved to LCM last year. Both at Woodsford and at LCM have worked on a lot of CAT cases, and so I'm here with that hat on.
Thank you. And finally,
I'm Lara Melrose. I co-head the litigation finance practice at Aldrich Global. We are a multi-strategy asset manager. We launched our litigation finance strategy in 2015. We make investments across the globe, but currently with particular focus in the UK and Europe, and have investments in the competition space.
Thank you. Okay, we've got probably about 40 minutes left. We really do want to do this a little bit differently if we can. We've got a few questions that we can ask ourselves, as it were, but we would like to get some interaction from you guys if you would like to. It's a fascinating space. The whole day has been fascinating. But if you have questions, now is the time to put them to the panel. So please feel free, just chuck your hand up and we'll try and answer them. So, kicking off, what are some of the key developments and challenges in the CAT proceedings currently? And Jen, as you the last to arrive, do you want to be the first?
Do you know, I'm not sure I was. Well, I was definitely not the last to be mic'd up.
Oh, okay.
But I'd love to go first. Thanks. So, as I just mentioned, I'm working on the umbrella merchant proceedings, and if I'd said that...
at the back? Great, sorry.
If I'd said that a couple of years ago, you'd all be wondering what on earth I'm on about, and some of you probably still are. But these umbrella proceedings, this whole procedural approach, I think is one of the big developments and challenges at the moment. It's been brought in, this procedure, by Marcus Smith, the President of the Competition Appeal Tribunal, and I think the main reason at the time he brought it in was because he was looking at the Merrick's claim, which we all know a lot about, and my client's claims and other claims that have been brought by a large number of other lawyers on behalf of merchants. And the claimants I'm representing are direct purchasers, and Merrick's is an indirect consumer claim. And Merrick's and the merchants, they're not arguing over the same pot of money, but one is arguing that it's all been passed on to them, and one is arguing that none of it's been passed on. And I think Marcus Smith was looking at that and thinking, how am I going to be able to deal with these types of issues in one go and make sure that there's no inconsistency in judgments? He was also looking at a very, very large number of disparate groups, individual claimants. Some had filed in the High Court, some in the Commercial Court, some in the Competition Appeal Tribunal. And he wanted to finally put an end to interchange litigation. And on that front, I really hope it works, because I've been working on interchange litigation for about 10 years now. And so these umbrella proceedings pull all of those claims in together, and ostensibly, whatever the judgment is from the trial we're in at the moment will be binding on all of them, even if you haven't participated, even if your claim stayed and you haven't even pleaded it out. The CAT has given all of these claimants the opportunity to put their hands up and say, we want to be involved, and has said, if you don't put your hand up and say, I want to be involved, then you just have to cope with the result. You don't pay any costs, you face very little adverse costs risk, but you don't put your case to the court and you're bound by whatever the decision is. The way it's being managed at the moment is in a very, very hands-on case management approach. We're having fortnightly mini CMCs, which thankfully have moved from 8 a.m. on a Friday to 10:30 on a Friday. I think our council team are particularly happy about that. The idea is that we avoid having to make applications. Marcus Smith seems not to like making orders. It does make things a little tricky because certainty is somewhat absent from proceedings, and it makes it quite expensive. But I have to say that, speaking from the claimant perspective, having mini CMCs does really stop the defendants from the whole delay tactic, because by Wednesday they've given up on pushing back against things, and they're trying to show that they're being very progressive about it. So I'm a big fan of them. It's just that they are pretty bloody expensive. So that's what I wanted to say about the umbrella proceedings, and that's really with a view to solving pass-on as well, which I'm sure isn't going to happen. I don't think there's a way of solving pass-on. Before I move on, did anyone want to ask any questions about it, or?
Any questions from the floor? No. Very good.
Is there any way you would like the claims to be managed better, or I guess, if hit Marcus Smith this time again, is there anything you think you would do differently, or anything you would like to see done differently?
Well, yes.
Chatham House rules. So
yeah. Is it? Okay. I think there's... Marcus Smith likes figures and he likes economic evidence, and that's great, but he is kind of chucking out of the window the common procedural approach to litigation. And there's a reason that we have disclosure and witness statements and expert evidence, and we do it in that order. And if you've got split liability in quantum trial, you do all the liability first, because then you don't have to go on to quantum next. And he's kind of just chucked that all up in the air and seen where it lands. And that is frustrating, and it makes it expensive, and it also makes it extremely unpredictable. And that, therefore, means that AT insurers and litigation funders aren't as keen on these cases, and you're not going to get quite such favourable terms, I think, because there's more risk in that approach.
Good. Thank you. Lara.
So I was just going to touch on an interesting and positive development last year in the Google AdTech proceedings, which I know Julian is involved in. So that claim relates to the online display advertising. So when you visit a newspaper and there are ads appearing on the side of your screen, the claim relates to the relationship between the publisher, so the newspaper on the one hand, and the advertisers on the other, which is all governed by the ad stack and a series of ad servers. And the French Competition Authority back in 2021 had found that Google was dominant in that ecosystem and had abused its dominance. That led to two applications being filed in the UK in the CAT. The first was by Claudio Pollock in November 2022. They instructed Humphreys, Kerstetter and Gerardin. And then following that, a few months later, in March 23, a second application was issued, this time by Charles Arthur, instructing Hausfeld. And so that obviously gave rise to a potential carriage dispute. Helpfully, at a CMC, the tribunal decided that, in contrast to what it had done in the FX proceedings and the trucks proceedings, it would determine the carriage dispute ahead of certification, which in itself was an extremely positive development. And in coming to that decision, the court gave some quite useful guidance on what its approach will generally be, and it confirmed that generally it will look to hold that carriage dispute hearing ahead of certification because of the obvious cost savings that would result in. It also encouraged rival PCRs to seek an early listing of the hearing and to work together in that respect. It said that defendants generally shouldn't have much say in that hearing and in fact needn't attend at all. I strongly suspect that defendants will look to attend hearings as they happen, but that they needn't have a prominent role. And the tribunal also said that the first to file is not determinative of the carriage dispute issue, although if there is a very long gap between the first application and the second application, that is something that it would consider. So that was all extremely helpful guidance. But actually the hearing never took place because for the first time the rival PCRs were able to agree an amalgamation or consolidation of the two claims. And I think that's a great development. The way they achieved that was they set up an SPV where the two PCRs are partners, and then they appointed a third representative, Kate Wellington, a consumer rights champion, who will assist in resolution of deadlock scenarios. And so the claim is now amalgamated, that's been approved by the CAT, and the certification hearing will happen in a couple of months' time. I think, will this happen again? I very much hope so. From a funder's perspective, it's obviously extremely positive development, but I think there were a few different factors which were relevant to this particular case. The first was that the two applications were broadly pretty similar in their approach and the theory of harm that was adopted, and I think that was because they were able to benefit from the French regulatory decision, investigate other regulatory investigations elsewhere, and litigation ongoing in the States. And so the theories of harm were very similar, and so the claims could be amalgamated in that way. Secondly, the PCRs were amenable to working together. That's critical. I think it's something that needs to be thought about when funders and also law firms are looking at selecting PCRs. This is an obvious a risk that often arises. And the final element was the funders, the ATE insurers, and the legal teams were able to cooperate, work out a way that they can all work together. You know, that takes a healthy amount of compromise on both sides and a very commercial approach from the funders, and so it'll be interesting to see if that can be achieved again.
Great, thank you. Just for those who've gotten the original question, we're looking at the key developments and challenges in the CAT. Julian?
I think on the question of whether amalgamation will happen again, it will partly depend on how the tribunal deals with the certification application. Because if it decides it wants to unpick the deal that's been struck between the two claim vehicles, then it may well be the first and last amalgamation. And in particular, we finished up, because there were two solicitors involved in one of the claims, we finished up with 3 solicitors' firms and basically a large counsel team, because as yet no one's been kicked off, although obviously not all the counsel have been involved at different stages. But Google's moaning about that. And I think if the CAT, basically says one of the solicitors' teams has got to leave, I suspect that will reduce the enthusiasm amongst the legal teams to do this again. Also on carriage disputes, the carriage dispute went ahead in the Amazon buy box case, even though people knew that the AdTech claims were amalgamating. An interesting point from that is that in the judgment, the CAT said that the unsuccessful claim in the carriage dispute should generally be stayed unless it was rejected because it was entirely hopeless. And that's potentially got cost consequences for when claims do amalgamate, because what Google is saying in AdTech is basically the amalgamated claim is just a Pollock claim, sort of rebadged, and therefore the Arthur claim's essentially been sort of dismissed, and we should get all our costs associated with that immediately, which provides quite a big disincentive for the amalgamation. More generally, the certification threshold has obviously come down in recent judgments, specifically after the Apple batteries case, where the tribunal indicated it wanted some, basically the PCR had to go and get some disclosure and replead its case. I think there was a concern, it was probably wrong, but there might be some sort of weight of evidence test that was being applied, even though Merrick's had obviously said it shouldn't be considering merits at the certification stage. I think it's now clear from the judgments that's not the case, and I think probably we're moving to a position where certification should be determined on the same sort of basis as strikeout and summary judgment applications, i.e. that unless there's something very obviously wrong with them, the facts as set out in the claim forward should be assumed to be true for the purpose of certification. So the focus is much more on the precision with which the claim and the theory of harm has been articulated, and how are the various issues that arise going to be determined, and can they be tried in an effective way. Relatedly, the tribunal in a couple of judgments has been praising Meta in the Gormson 2 judgment for not taking too many points on certification, and also having a bit of moan about the amount of evidence which has been submitted for certification cases. I hope once defendants realise that the certification threshold has come down, and the tribunal is not going to entertain sort of very detailed, granular points about the methodology which would be more appropriate for final trial, that we'll see the volume of material and therefore the costs associated with certification hearings coming down. Just finally, I'm involved in the Roberts sewage spill claims. We've got our first CMC coming up next week. I think when that was first publicised, there were quite a lot of people thinking it was a sort of weird environmental claim which had been sort of shoehorned into the regime. Hopefully, from the summary that's been published on the CAT website, competition lawyers can now see that that's not the case. There are, however, quite a lot of issues arising about the extent to which competition law should be applied in this extremely highly regulated context. Those issues will probably fall to be determined either by strikeout applications dealt with at the same time as certification, or as preliminary issues shortly after the certification hearing.
Great, thanks. Jenny?
Well, I thought I'll just touch on 3 different cases which will be of interest in the kind of funding world. The first 2, the Sony PlayStation case, and the second, the commercial interregional card case. In relation to the second claim, I should say 2 of my partners are running that case, but I'll do my best to talk about it even though I'm not directly involved. In relation to the Sony and commercial interregional card cases, the CAT has approved revised funding agreements kind of post-PACAR, which is what will be of most interest to people in this room. And in the Sony PlayStation case, it was that they approved that the funder's return could be based on a multiple or a percentage to the extent permitted by law, and this was a particular point that was kind of tested during the hearing, and the CAT determined there could be no logical possibility that the DBA regulations could be engaged by a clause which contained the phrase only to the extent enforceable and permitted by applicable law, to make the return provisions unenforceable. And the CAT observed those provisions could also be severed if they were otherwise enforceable without changing the character of the agreement. So overall, the CAT concluded that the wider provisions of the amended funding agreement did not cause the DBA regulations to apply, and the funding arrangements that were being proposed did not create unacceptable risks of perverse or unmanageable incentives contrary to public policy. So the bottom line being there in that case that it would appear that multiple only based funding arrangements won't be subject to the DBA regs, and where a percentage based return applies only if the law changes, but that case is actually going to the Court of Appeal. And similar finding in the commercial interregional card claims case, which had both opt-out and opt-in proceedings. In the opt-out proceedings, there they approved like a multiple by reference to the amounts expended by the funder and insurer, rather than a percentage of the proceeds. In the opt-in funding arrangements, this one was a slightly different structure because that's where the law firm had entered into the relationship with the funder. And that particular point was stress tested. And so what was kind of concluded there was that the distribution of the proceeds should be subject to the relevant clauses being enforceable or permitted by law, failing which an alternative provision would be put in place, which would be a multiple. So those decisions were in November and January respectively, and they are both now going to the Court of Appeal, and I think there's going to be a consolidated appeal in a number of different cases on public interest grounds, but that's not actually slowing down the progression of the cases. So in the commercial and interregional card case, there's a CPO hearing in April that's going ahead. And then just touching very briefly on something kind of hot off the press is the Gutman versus Apple case. I won't talk too much about that because I think someone else on the panel might be, but just kind of the point that's relevant for the funders in the room is that the funder's fee not being confined to being taken only from an undistributed portion of damages, and the CAT sort of said there's no reason why they can't apply discretion to allow payments to funders out of damages, but it has to be proportionate to the amount the claimants are getting. So I think sort of overall the kind of the conclusion from the 3 different judgments is that the CAT is being supportive of funding arrangements. It recognises that these cases can't be brought without it, but that funders are also in it and it's a business and that they have to be able to make a return on it. And I think that's a really positive message.
Great, yes, absolutely. And now finally, you, Adam, and again, if you could just focus on the effects for the funders.
Yeah, I think the challenges for the funders are really similar, I think, to the challenges that the CAT is going to face when it has to look at these claims, many of which are highly sort of technological, in that they are claims brought in the technological arena. And I think it's hardly surprising. In the 1990s, Bill Gates predicted that big tech would overtake banks and become the most powerful corporates in society. And without a shadow of a doubt, he was bang on the money, and indeed Microsoft is now the biggest company in the world by market capital. And you just need to look at its peers, and Apple's up there, and I think Meta's not far behind. What that leads to in the competition sphere is that, particularly in abusive dominance cases, there are a lot of claims being brought against big tech. And I'm not a competition lawyer, but even I know that market definition and where you delineate the market and understanding a tech company's role within that market and the importance of two-sided markets and how you look at those, these are all key questions that you really need a very firm understanding of the technology and the market that technology is sold in and operates. And I think the CAT is billed as an expert tribunal, and there is some very impressive expertise at the CAT. Every tribunal, you have 3 judges, the president or a chair, accompanied by 2 ordinary members. They're anything but ordinary. You look at their bios, they have expertise often in economics, but also in accountancy, finance. And if you look at the CAT's website, it describes the ordinary members as not just coming from economics, accountancy, finance, business, but also from technology. But I took a few minutes yesterday to quickly scan through the bios. There's about 40 ordinary members on the CAT's website. And I was a little bit concerned that I could only really find, unless you count physics and nanotechnology, which I think is too specific to be that relevant, there was only really one judge on that list that professed to have expertise from the legal side, in that she's a professor of law, but she mentioned the digital economy and online platforms as an area of her expertise. And there's a handful of others that have expertise from the payments world, which clearly, with all the interchange litigation that is in the CAT, that is going to be very key. But I do, personally for me, when I'm reviewing cases, I think unless it's accompanied by a very good industry expert's report that explains the wrongdoing in that context, it takes me longer to get to grips with the case. And I think the CAT is going to struggle. And of course, we heard from Jen how Marcus Smith is making it all expert-led. But I think it's not just the economic experts. You're going to have a lot of technological expertise, and I think that is a challenge. And Julian, I don't know if you want to add to that. I know we briefly exchanged emails on this.
Yeah, I think in a way it could get even worse. A lot of the collective claims take their inspiration from a sort of previous regulatory decision, because you've got some sort of regulatory support, even if it's not a strict follow-on claim. And the CMA is about to start taking decisions under the Digital Markets Act. Regulatory decisions will be essentially finding dominance and some sort of anti-competitive effects. So you're going to have a greater potential for even more big tech claims than you have at the moment. And the other thing is you're going to start getting decisions relating to AI, which is even more of a black box than the tech markets. And I think in terms of getting the expertise, one of the problems is that a lot of the people you want are still in practice. And if they're in practice, because of the size of these companies, they're very likely to be working for big tech and to be conflicted out, or to not want to be involved in these cases just because it's going to, kill their day job. So the best category of people is people sort of towards the end of their careers and sitting on the CAT panel as part of a portfolio career. But it's going to take a while to all the people who've spent quite a bit of their life working in these sectors to actually get to that stage. So it might get easier, but probably not in the short term. It's
also quite difficult to get hold of expert witnesses, isn't it? If you want to have someone who's going to, in Visa and MasterCard, for example, we've been trying to find someone who can speak about what issuers do, but every issuer is in Visa or MasterCard's pocket, or was, and doesn't want to piss them off. So, they're all conflicted out one way or another. It's very, very tricky.
Good, thanks. Lara, again, can you give some specific examples about the challenges that funders are facing?
Yeah, I mean, I was just going to talk a little bit about the tightening of the availability of funding as it was put in one of the earlier panels today. I think the regime has obviously undergone some challenges of late, PACAR being the most obvious one, but if you look at the number of CPO applications that are being filed, it's still alive and well. So last year, I think there were 17 CPO applications filed compared with 15 the year before. So the number is still increasing. But funders are undoubtedly facing a concentration risk, and what is meant by that term will be very specific to each funder. So it could cover jurisdiction, forum, claim type, defendant type, or a combination of those things. But if you also look at the funders who are on the record as funding CAT claims, I could count 13 from what was publicly available. The number will be a little bit higher than that, but compared to the number of CPO applications and live cases there are, that's actually not that many. So I think it's unsurprising that those law firms in the market who are trying to launch new CAT claims are finding it harder to find the capital. The fact that the costs are just getting higher and higher doesn't help the situation. We're looking at least 20 million for a typical CAT budget now, I think. And against the likes of Google, Amazon, Apple, extremely well-resourced, deep-pocketed defendants who are fighting absolutely every element of each claim. So that, as we know, really very risky. And I think a quarter of the claims are in the digital sector. That doesn't mean the funding is going to dry up, far from it, and I don't think that's what we're hearing from the market. But one of the earlier panels was talking about co-funding. That is one obvious solution to the issue. We do a lot of co-funding. We think it works really well in terms of managing the sort of diverse concentration risk and providing sort of a diversification tool. I think one of the funders who spoke earlier today was expressing some hesitancy around co-funding. I think you need to be careful with who you're co-funding, but there's some fairly easy steps you can take to ensure that that relationship will be a successful one. So, as well as checking getting comfort about the capital and the availability and depth of that funder's capital, it's also just so much comes down to relationships and ensuring that as a funder you understand what the priorities of the other funder is that you're co-funding with, or the other funders that you're co-funding with, what their approach will be when the things get difficult in sticky situations, what they're expecting from reporting from the other law firm if you're the front funder or you're sitting behind them. As long as you do that, there's no reason why it can't be a very successful co-funding relationship, and I think we will just increasingly see more and more of that.
Good. Julian, do you want to add anything to that?
Well, I think just in terms of the costs, I mean, if you can identify sort of mission critical issues, which if you lose on it, you're going to lose the entire case, it may actually be in the funder's interest to have those determined sooner rather than later. I mean, the defendants obviously sometimes want to do that because they can knock you out, and potentially, if it's a point of law, they can have an appeal which will just delay everything for a couple of years. But there is a sense in which, given the amount of money that gets spent on these claims, that if you're going to lose, you might as well lose quickly.
I do wonder, though, with the sort of trend the CAT seems to be adopting in having a series of mini-trials to deal with sort of distinct but sequential issues, that seems to be with the good intentions of managing costs. But I wonder if that is that effective, because, as we know, trials, even mini-trials, are extremely expensive. I think that's obviously your experience, Jen, on interchange. And it also doesn't help with the duration risk, and because every time you have a mini-trial, you have to wait for a judgment, and so that just increases time and delay for the cases. Cynically, I wonder whether part of the motivation for the CAT in ordering those mini trials is down to resourcing, because obviously a trial that's a couple of weeks long is much easier to resource than one that's 16 weeks long. So I think there's probably dual motivations there.
Yeah, I think that's absolutely true. In fact, I think the tribunals, accepted that part of it is due to resourcing. But the other issue, obviously, is that Marcus Smith and other members of the tribunal do often get appealed, and successfully appealed as well. So if you're having numerous trials in interchange, for example, there won't be, because ultimately it will settle. I keep saying this to myself. But there could be up to 4 trials, and that could go on up until 2026. And then at the same time, you're presumably going to have, in parallel, appeals of the judgments, because Visa and MasterCard aren't going to give up anytime soon. Google isn't going to give up. Amazon's not going to give up. None of these big tech companies, they've got enormous amounts of resources. They're just going to fight everything all the way through.
Well, I guess the issue then is whether actually the proceedings continue in some way before the CAT, if you keep progressing things, notwithstanding the ongoing
Well, I think
appeal.
you do, yeah. Then that's an issue as well, because what happens about the costs that you've spent on trial 2 if you ultimately lose trial 1?
Interesting. Okay, well, I think that brings us on to another point that I wanted to raise, is duration. Obviously, as a funder, we want the claims to resolve as quickly as possible. Jenny, do you want to just comment on duration?
Yeah, sure. I think issues around duration are common to either competition cases or just cases generally, aren't they, really? So, how do you encourage settlement? You want momentum, pressure and speed. And I think speed is a real problem in both the CAT and in any High Court proceedings. It's difficult to get hearings of any length. In relation to kind of CAT, just chatting with some of my fellow partners about this, is needing to be quicker to get to CPO hearings, because once you get a CPO, you're on a trajectory to a trial. That adds some momentum and some pressure, and it's been taking up to 2 years sometimes to get those CPO hearings, which is just sort of delaying access to justice, isn't it, and not pushing things on, which is a problem in terms of trying to put pressure on the other side to settle. And just there's really no reason really for CPOs to take so long, because the certification process is provisional anyway. There's opportunities for defendants to come back and challenge certification at a later date, but without the certification there are just going to be real delays to the progression of the litigation. So I think that's the target, to try and push that on faster as much as you can.
Good. Adam, do you have any good news on duration?
I'm sort of, maybe like Rosie, I'm ever the optimist. I sort of am encouraged by the fact that when the stars are aligned, things can go quickly. You look back, I think it was 2021, January, that BT and Le Paterel and BT was issued. It was heard for certification in June, and judgment was handed down by the end of the summer. So by September, that's not a terrible timeline for an issue. Now, of course, BT appealed, and I think even with that fairly significant appeal, the CAT has done well to get this on for trial now. 2024, we're 3 years after it was issued, and we should have a conclusion fairly soon and hopefully judgment thereafter. So 3 years, including a significant appeal of certification, I don't think is terrible. I also think that these appeals that we've had a lot of, they are teething problems, and there will come a time in the not too distant future when defendants will run out of license to appeal they'll go for permission to appeal, and at the moment it's a very permissive avenue, because the Court of Appeal is keen to try and clarify as many of these points as possible, but there's only so far that can go. And I think I'm also encouraged by comparing where we are in our teething problems here in the UK compared to, say, Canada, which is a very significant jurisdiction because it informed the CAT regime here, looking at 30 years of jurisprudence from Canada. And you can see in the appeal that happened on that bizarre in McLaren and Mole and the other roll-on, roll-off ferry cartelists, an appeal was taken on a point about whether the defendant could communicate with class members. And when it was heard on appeal, one of the sort of points that was accepted by Popplewell, who I think gave the leading judgment, was to look at Canada and see what they do there. And Canada, the regime started in Ontario early 90s, and the two cases that resolved this issue in Canada were dated 2007 and 2016. So, from 1992 to 2016, that's a significant 24-year chunk to resolve that issue. Well, we resolved it last year, 8 years after the regime, kicked off. So I think the UK will catch up with its common law peers, and I really do think that these constant appeals will become a thing of the past, and it will be much more exceptional that cases will need to be appealed on almost every point.
Okay, Lara?
Yeah, well, I'm encouraged by that positive bit of news. I'm struggling to think of another positive thing to say, actually, on it.
You really are miserable, aren't you? Okay, well, let's go for the positive. Julian?
One of the positive things, I think the CAT has been trying to list certification hearings more quickly in some of the most recent cases. I mean, almost at a slight sort of breakneck speed, but that's a good thing. I think there's obviously this big pass-on issue. I think the appellate courts would like to try and simplify it all, and it may be that interchange is the case that they get to do it in. Because obviously that's a whole separate bit of litigation in itself, dealing with pass-on. In terms of strategy, one possibility in some cases is if you identify a sort of sensitivity on the part of the defendant, say you can potentially try and have those issues tried first. So there's been litigation in the CAT where Microsoft is a defendant, and Microsoft said it wanted the abuse trial to come before the determination of market definition and dominance, because it was absolutely desperate not to be found to be dominant. And obviously if you win on that case management issue, you might have got some settlement leverage quite early in the litigation.
Okay, great, thank you. Well, look, I can't believe it. Time is going very quickly. We've got loads more questions, which you can probably imagine, and I think we could speak for hours and hours and hours. Does anyone have a further question from the floor? Yeah.
Hi. Just putting together a few of the points that you mentioned in relation to duration. Obviously, we have, as fund the increased budgets in the CAT, we have probably limited appetite because of the uncertainty, the PACAR impact, the fact that everything is being appealed. Jen, you mentioned the lack of a settlement dynamic against big tech. They've got unlimited money and they can just push it on. In some of the earlier cases, definitely on the opt-out side, a strong investment thesis of the funder was that there would be, they'd be fighting, there'd be a lot of skirmishes, and of course it's much more expensive and it's taking more time than anyone thought, but there would then be that settlement dynamic in those opt-out cases because of the ability potentially for the defendant to take back anything that was unclaimed by the class as damages, and that was seen as perhaps quite a unique feature of the CAT. Do we think that settlement dynamics still applies, and is there a similar settlement dynamic or not in opt-in cases? Because if there's not, these cases at the moment in future do feel quite difficult to fund unless they're, the only thing you're waiting for is a wave of settlements. I just wanted to hear the panel's thoughts on, do you think that investment thesis still applies, or is it a bit more risky than originally anticipated?
Sure.
That's a very good question. Adam,
I was going to just mention one case that I was peripherally involved in when I was at Woodsford, which is the Ro-Ro settlement that we had in December. I think that's a very encouraging settlement. I think the court said that although they didn't approve the reverter at that hearing, because it was made clear that that wasn't what, I think it was Nick Bacon that was asking for it, but the court did say this is reasonable, and it's clearly it's been structured in a very clever way. I had nothing to do with that. I'm not blowing my trumpet, but it's very clever that the first defendant, now to have settled, is now the first in line to get the reversion if the PCR's application or the class rep's application at the end of the day is accepted by the CAT. But the class rep now is under a contractual obligation to basically seek that from the CAT at the end. And that creates an incentive for all the remaining defendants, who are all cartelists, to jump on the settlement bandwagon. Now, on that case, you've got an interesting dynamic, because the defendant that settled is the smallest defendant. I think it got something like 1.7% of the alleged damages. And it was the only defendant that didn't contest certification. So clearly, there's a difference between its appetite for this litigation and the others. But I think going back to the rules, that's the first case the settlements have been considered. The CAT was very clear that reversion to the defendant, there's only jurisdiction to do that where it's a settlement, and so there is a really significant risk of going to trial. And ultimately, the more of these appeals that resolve all these uncertainties, the less scope. It will come a point where counsel and solicitors, they won't be able to advise defendants to take a point to appeal, because it just won't be arguable anymore. And then at that point, when on an interlocutory issue a defendant loses, rather than opt for an appeal, they'll be like, right, let's talk settlement. And that's how I see it, but who knows?
I think that's right. I was just thinking about the weaponisation of costs by defendants who know that you've got funding in place and know that there's a multiple and there's various stages when it will ratchet up. And the way that the CAT's approaching this is quite useful, because even though having fortnightly mini CMCs isn't particularly cost efficient, they are taking a very proactive approach to proportionality. We recently voiced some real concerns about the expert approach, the evidence that they were seeking to obtain. MasterCard was taking this sort of we must have evidence from everyone type approach, no doubt to get us to rack up enormous costs. And the Competition Appeal Tribunal actually said, well, look, if the defendants are asking for this and we think it's useful, then we want the defendants to participate in the gathering process, the data cleaning process. They can pay for part of it, share the costs between you if the evidence is necessary, which was quite a good way of approaching it, I think. The other thing that I think, it might be worth litigation funders thinking about is whether once you've won the first trial and you've got your costs, there is an opportunity to, put the terms back a bit, reset the terms, come up with something that is going to cause your clients to fight a bit harder and get a better outcome, rather than being so scared that they're going to get so little back because of the funding dynamics that they'll just settle at a much, much lower amount than they would otherwise go for.
Okay, thank you. I'm going to ask the panelists if there's just any one further point that they want to make. We're really running out of time now. Julian?
Yeah, I suppose we haven't talked about distribution very much.
We haven't, yeah.
I think, obviously we're going to find out what happens in the Pactual.
Yeah.
I would expect that in cases where it's possible, the tribunal and any relevant regulators might be quite keen on account credits, because it produces much higher levels of sort of take-up or compensation. That obviously presents some challenges to funders, although we do obviously have the Court of Appeals comments in the Patriel about funders being able to take their cut before the distribution. I'm also quite hopeful that the courts will be sort of slightly relaxed about a broad brush method of distribution. We've already had comments in 2 Court of Appeal cases saying that it's open to the tribunal to consider innovative methods of distributing and creative approaches and so on. So I would expect them to be flexible, and hopefully that will reduce the cost at that stage.
Great. Okay, look, we're almost there. Before we finish, I would like to ask everyone out there, if you cast your mind forward 12 months from today, when we're all sitting in this beautiful ballroom again, do you think the cat will be in a better position or a worse position? Anyone thinking it's better? Can you please raise your hand? Oh, perfect. And anyone who thinks it's going to be worse? So things are moving in the right direction.
Quite a few neutral people as well.
No, it's all positive. We want to end it. Look, I've personally really enjoyed the whole of today, so thank you again, Eleanor and Brian Rudnick. Really amazing. The thing that I found most incredible was Neil Perzo, I don't often say that, but his comment about the post office, where the post office has spent £100 million pursuing that claim, and if that had been given to the postmasters on day one, they would have got 9 times what they have finally received 8 years earlier. Now, that really, I think, is so sad, and I just think, obviously I'm talking my own book. I think funding can help people get access to justice. I think the CAT is a wonderful platform, hopefully, and we want it to succeed. We actually want 1 or 2 settlements to come out in the not too distant future. But I've really enjoyed this panel, so thank you very much, all of you, and thank you to you as well. Thanks.
Thank you, Bobby, for this very interactive panel, which concludes our conference. I wanted to thank you, the panelists, our keynote speaker, and I know some of you have a flight to take, but if not, we're waiting for you for drinks and canapé. Thank you all for coming.